morning, sir. With the permission of the Honorable Court, may I proceed? In the Court of Civil Justice Class 2nd, right for the number 6, rule number 17, shoot number 149, year 2018. In the case of Sri Rohit Singh, son of Sri Rajendra Singh, aged 40 years, resident of 820 Lakshmi Nagar, Sundarpur, Varanasi, 22-1005 versus Sri Jagdish Yadav, son of Jayant Yadav, aged 43 years, A19 Lakshmi Nagar, Sundarpur, Varanasi, 22-1005. Suit for seeking relief of specific performance and permanent injunctions. Treated under order number 6 of CPC 1908. The plaintiff begs to submit under plaintiff file a suit seeking relief of specific performance of contract as well as permanent injunctions on the ground that on 6/1/2015 the defendant number 1 entered into an agreement to sell the shoot plot at measuring 4271 square feet for a consideration of Rs 15 lakhs. At the time of execution of agreement, a sum of Rs 13 lakhs was paid. It was agreed between the plaintiff and defendant number 1 that on receipt of the balance amount for which no time limit was prescribed, the defendant number 1 would execute the sale deed in favor of the plaintiff. It is in the case of the plaintiff that under the agreement the possession of the plot in question was handed over the plaintiff. However, on 15/1/2018, the defendant number 2 informed the plaintiff that the consideration which has been raised by him or on the plot in question is unauthorized. Thereupon, the plaintiff informed him about the agreement dated 6/1/2015. The plaintiff got a notice published on 21/1/2018 in newspaper Dainik Bhaskar and sent a telegraphic notice to defendant number 1 on 21/1/2018 to execute sale deed in the favor of after receiving remaining amount of Rs 2 lakhs in his favor. Plaintiff until now always was ready and willing for execution of sale deed in his favor by paying the balance amount to the defendant. Thereafter, the plaintiff filed the suit seeking relief of specific performance of contract and permanent injunctions, restraining the defendant number 1 from alienating the shoot plot. Alternative relief plaintiff pleaded that if decree of specific performance in his favor is not possible, then the defendant to be ordered to return in advance of Rs 30 lakhs with a 15% per annum interest, and he also claimed compensation of Rs 5 lakhs from the defendant for losses barred by him. The Specific Relief Act 1963, a specific section related to relief, particularly specific performance of contract under section 10 of the Specific Relief Act 1963 allows for the enforcement of specific performance when damages are inadequate. In other case laws, Madhusudan versus Madan Lal 1950, this case illustrates how courts began to approach specific performance in land transaction. The plaintiff had agreed to sell land, and but the sale was later denied. And the second case law, the Manpur versus Hartar Singh Sangha, year 2010. This case highlighted the requirement for the plaintiff to prove their readiness and willingness to fulfill their part of the contract, even if the defendant breached, except as otherwise provided in this chapter. The specific performance of any contract may, in the discretion of the court, be enforced when there exists no standard for certain actual damage caused by the non-performance of the act agreed to be done is such that case law Surinder Kaur versus Bahadur Singh, a recent judgment passed by the Supreme Court of India, the granting the relief of specific performance for being entitled to get the relief of specific performance, and aggrieved party in contract must have fulfilled all necessary conditions and must also ensure that there are no loopholes on his part. Only then can the relief of a specific performance be granted. In this case, the Supreme Court bench consisting of Justice Deepak Gupta and Aniruddha Bose, while deciding on the question to whether a grantee who fails to perform one of his promise as mentioned in the contract can be subjected to the relief of specific performance for that contract can be subjected to the relief of a specific performance. I want to present the plaintiff evidence on my behalf. The plaintiff examined himself and proved agreement Exhibit P1 and also examined PW2 Ramesh, attesting witness of Exhibit P1. In his support, plaintiff further relied on admission of defendant number 1 regarding execution of agreement and stated that he is a possession. Under some other case law, Sara Damni, Kanda Appa versus Raj Lakshmi and courts on July 2011 against respondent 1 to 4 seeking a decree for a specific performance of the agreement of sale dated 17/1/1981 and our direction to respondent plaintiff is entitled to the following issued where framed in specific performance in favor of the plaintiff whether the respondent that committed breach of the contract.
Good morning, sir. May I proceed? I, Rohit Khare and counsel in the Honorable Court of Civil Judge Second Class to request the court by the defendant and counsel to submit the written statement. The defendant and counsel rejected the plaintiff's pleading are as following. First, the agreement to sell the suit plot area 4071 square feet, considerations of rupees 15 lakhs for the security loan in the date 6 January 2015 and never placed by the plaintiff was taken possession. Never placed taken by the possession. Point number second, the plaintiff was got a notice 21 January 2018 sent by defendant Jagdish in newspaper Dainik Bhaskar and Telegraph. Point number third, the plaintiff pleading that if the degree of specific performance in his favor is not possible, is the plaintiff pleading that, sir, if the degree of specific performance in his favor is not possible, then the defendant to be ordered to return advance of rupees 13 lakhs and bank interest also. Point number 4, the defendant number first execute the sale deed registered sale 55 lakhs rupees, defendant number 2 and Srimati Lalita. Point number 5, the defendant number first the sale deed 16 January 2018 and 17 January 2018 in favor of the defendant 2 and 4. Point number 6, the plaintiff suit submitted in time barred in limitation act. Point number 7, they got the plot in the question of possession to decriminate in 13 January 2018 by defendant number 2 and also 4 are bona fide purchaser for the value consideration without notice. Defendant evidences, sir. Defendant number first Jagdish examined himself and stated that the agreement was executed by way of security for loan. He by registered sales deed should his plot for amount of rupees 55 lakhs to defendant number 2 and 4 Srimati Lalita. provided the same, exhibit D1 and D2 executed by defendant number first by in the cross examination. She admitted that incident of herself, son made an inquiry from Patwari, and that defense number first is the owner and in the possession of a plot. Some regarding case laws are presented. Contract cases. Number first, K.S. Vidyanandam versus K.N. Vidyanandam and others versus Berayavan 1977 3 SCC 1. The court principle, even though the time is not generally of the essential in the immovable property, contract inordinated, deny and lacks of the action on a part of the plaintiff can decentralize him from the referral. Case number second, Mankaur versus Hartar Singh Sangh 2010 10 SCC 512. The principal plaintiff must prove a continuous readiness and willingness to perform his part. Case number third for the agreement as security loan, sir. Regarding as case Krishna Mohan Kaul versus Pratima Matai 2004 9 SCC 468. The court principles sheds, sir, where a document is declared to be a sale agreement by intended as a loan security, court may be examined by substances over the form. Fifth case, sir, regarding Limitation Act and specific performance. Ramjan versus Hosseini 1991 SCC 104. If court principle, if the plaintiff does not show within 3 years of the cause of action, the suit is barred by the limitation. The limitation barred under the Article 54 of the Limitation Act, sir.
The argument of plaintiff on my behalf. The learned counsel for plaintiff submitted that since the defendant number 1 has taken a stand that agreement is executed by way of security for the loan, therefore he is not entitled to take advantage of provision of Specific Relief Act 1963. It was further submitted that under the agreement the plaintiff had paid substantial amount sum of Rs 13 lakhs out of the total sale considerations of Rs 15 lakhs. Therefore, defendant plea that the plaintiff is not ready and willing to perform his part of contract is not enabled. It was further submitted that does not prescribe time for making payment of sale considerations, and therefore time was not the essence of the contract. It was further submitted that subsequent purchaser cannot raise a plea that plaintiff has failed to prove his regardless and willingness. It is also submitted that defendant number 2 to 4 did not make any inquiry prior to execution of sale deed with regard to previous agreement with plaintiff. In case where a defendant breach a contract in favor of a plaintiff, the plaintiff can seek legal remedies of after including compensation for damage or in some cases specific performance. The key is demonstrating that a contract exists, the defendant breached it, and the plaintiff suffered damage as a result. Indian law, specifically the Indian Contract Act 1872, provided framework for addressing such breach and seeking approach compensation. Monetary compensation for the loss suffered by the plaintiff due to breach of contract. So as alternative relief, plaintiff pleaded that if decree of specific performance in his favor is not possible, then the defendant to be ordered to return in his advance as 30 lakhs with the 15% per annum interest, and also claim compensation 5 lakhs. from defendant for losses barred by him. So there my client Sri Rohit Singh, the defendant number 2, informed the plaintiff that the construction has been raised by him on the plot unauthorized. Thereupon the plaintiff informed about the agreement 6/1/2015 to execute sale deed in his favor. Plaintiff until now and always ready and willing for execution of sale deed in his favor by paying the balance amount to the defendant. And landmark cases on the breach of contract in India have shaped the understanding of contract law, particularly regarding the consequence of failing to fulfill obligation under contract. The key cases of Hadley versus Baxendale, 1854. The English case is a cornerstone of contract law, established principle of remoteness of damages. It indicates that damage for breach of contract are limited to those losses are naturally arise from the breach and those that the parties knew and how to prove would result from it. And Sri Hanuman's Cotton Mills versus Tata Air Service, 1970, the court granted specific performance to the plaintiff because the defendant had failed to fulfill to the contract.
Respective court, argument of defendant and allegation to clarify by the respondent. Plaintiff argument: time was not the essence of the contract, as a contract started within 3 years in time limitation shoot against of defendant. Point number 3, inviting and attention of this court to the agreement of execution of the sale deed. The notice of defendant by the plaintiff has failed to prove his readiness and willingness to perform his part of a contract. The plaintiff, he is not entitled to decree for the specific performance of a contract, and colleague acts the contract of a contract under contract at 1872 section 2G and regarding section 10 to a specific performance of a contract, then why 3 years not should file for a question, sir? Thanks, sir.
Sir, I want to present some other case law. NP Thiruganaman versus Dr. R.J. Mohan Rao. The Supreme Court of India in the case of NP Thiruganaman versus Dr. R.J. Mohan Rao once again took into consideration the provision of section 63 of the Specific Relief Act 1963. The plaintiff in the case entered into an agreement of sale with the defendant. The plaintiff had to alienate property in the city of Madras in return of consideration of certain amount. The plaintiff paid a certain amount as an advance and also agreed to provide rent, and each month a suit was filed by the petitioner on the ground that the respondent was absent in the entire agreement and even failed to execute sale deed. The respondent claimed that they were willing to take a part in the agreement. They also mentioned that the plaintiff on his part did not provide with the sum of he was supposed to provide with. Once again, section 20 was looked at by the court while it stated that the remedy for a specific performance is equitable and at the discretion of court. Just being in an agreement does not satisfy. The fact of the remedy will be available to one of the parties whenever necessary. So another case law, the Gujarat Bottling Co. Ltd. versus Coca-Cola Co. 1995. The court issued an injunction to prevent the defendant from entering into a competing agreement while would have breached its existing contract with the plaintiff.
For the to continue for the cross points by the defendant, cross examination of plaintiff counsel. Point number first, page number 12, sir. Point number first, plaintiff's evidence PW2 Ramesh, attested witness, not independent witness, not independent witness. Point number second, plaintiff in argument, time was not the essence of the contract, but the contract started the Limitation Act 1963 for 3 years to plaintiff suits against defendant. Point number third, plaintiff pleading, sir, plaintiff pleading to possession of the plot, but defendant pleading plaintiff was never placed in a possession. And also evidences defendant number first, owner and possession of the plot. Point number 4, consideration of for previous transaction 13 lakhs rupees and interest in the plaintiff to return it by the defendant counsel to accept it. Point number 5, Transfer of Property Act 1882 section 55 subclause section 6, buyer is entitled rights and liabilities to present by the defendant to not clarify. So honorable court, hence I requested to kindly plaintiff failed execution for a sale agreement, the suit dismissed and no orders as to cost. Thank you, sir.
Sir, I want to present plaintiff file a suit seeking relief of specific performance contract as well as the permanent injunctions regarding case laws Hotel Leela Venture Ltd versus Airport Authority of India 2014. The court awarded consequential damage to the plaintiff for loss of business due to the defendant breach. Case R.K. Upadhyay versus State of Bihar 1995. The court awarded nominal damages to the plaintiff as it found a breach of contract but no evidence of substantial losses. And another case law, the Muralidhar Chatterjee versus International Film Co. Ltd 1943. The court recognized the right of the plaintiff to repudiate the contract due to the defendant's failure to pay royalty. So, sir, please, I have a humble request to you that you keeping in view all the witnesses and document, please give due justice to my client. And I prayed, it is prayed that a decision of declaration of title or relief of my client, if a decree of a specific performance in his favor is not possible, then Your Honor, then defendant to be ordered to return his advance, rest 13 lakhs with 15% interest per annum, and also claimed compensation, provided 5 lakhs to my client, Sri Rohit Singh. It's my humble request to you, and thank you, sir.
The plaintiff counsel, colleague sets allegation, sir, for respondent specific performance under SRA 19 Act 1963 to clarify in a pleading, sir, in highlighted page number 2, the defendant, if that the degree of specific performance in his favor is not possible, then the defendant to order to return advances only of 13 lakhs rupees with 15%, not so sure, sir, 15%, but in continuous to present bank interest to return it also, and also claim compensation of 5 lakh of defendant loss. Why the loss, sir? Loss only to 3 years, not suit file also, and a part of a contract. So he one time breaches the contract, sir, and the limitation is. Thank you, sir.